everybody. Glad you're sticking around. And for everyone who's new here, thank you for stopping by. So this panel is the Endangered Species Act and climate change. And of course, on behalf of this panel, we have adopted, symbolically, a polar bear from World Wildlife Fund. Again, please text and tweet all of your questions. The text number is 802-299-9112. And the Twitter that you can tweet at is @JournalVJEL. This panel is being moderated by our own Vice Dean Mears, who received his JD and MSEL from Vermont Law School in 1991 and first joined the staff in 2005. He returned to serve as the director of the Environmental and Natural Resources Law Clinic in August 2015, after serving 4 years as commissioner of the Vermont Department of Environmental Conservation. Dean Mears has extensive experience in the major pollution laws, including air quality, water quality, and hazard waste management and cleanup. This also includes water resources law, federal facilities regulation, and state and federal sovereignty. So it is my pleasure to introduce our Vice Dean and one of my favorite mentors, David Mears.
Who's your favorite mentor?
Oh, that's a secret. I'll tell you graduation.
Well, thank you all for being here. This is a really terrific turnout, and thanks to the VJEL staff and really to all the faculty that also helped pull this together. It's always astonishing to me that it's joyous in some ways. I was just talking about how much fun it is to work in this community of people where we can talk about these kinds of issues, which feel so central to where the world is and needs to go, and to have to be part of a community of folks who are really thinking actively about how we change the world. As I was watching Pat up here, I was hearkening back to listening to him now over 25 years ago when I took wildlife law from him. I got the worst grade I ever got in law school.
There's still time.
And as I introduced Jim Murphy to my left, and as I walked down, each of us have had people that have been central in our lives in terms of mentors, as moral guides. I carry Pat Parento on my shoulder with me wherever I go and whatever I do. I suspect for Jim Murphy, maybe you carry Zig Flatter along with you. I know Jim went to Boston College, had the pleasure of interacting with Zig at that time.
Research assistant.
Right. So I pass that on to all of you students that, this community of people is a community of people that you will interact with throughout your careers. And this topic isn't one we're going to solve today. But with that, I want to ask the panelists a series of questions that all boil down to a central question, which is the Endangered Species Act in the least bit relevant to the issue of climate change, or vice versa? Right? It's an interesting little law. It does its own little thing. And does it matter that we're in the middle of a major catastrophic change in our weather patterns? But so let me introduce the folks who are going to help us explore that question. To my left, I already introduced Jim Murphy. Jim Murphy is the Senior Counsel for Climate and Energy at the National Wildlife Federation, where he's been for quite a number of years, including a period of time when he came to Vermont Law School while he was working and got his LLM. But as I mentioned, he got his law degree from Boston College. But he's nailed the perfect job in the universe. He gets to work on issues all over the country and really the globe relating to climate change and clean water and wildlife protection. And he does it from Montpelier, Vermont, which is the best city in the universe. So Jim, thanks for joining us. To Jim's left is Mark Fink, who is the Senior Attorney for Public Lands Legal Director for the Center for Biological Diversity. And you heard Pat describe earlier how citizen suit litigation has shaped the Endangered Species Act. And I think it's safe to say that there has been no other environmental organization that has so single-handedly focused on the use of the Endangered Species Act citizen suit provision to change the nature of endangered species policy in this country. And Mark has been at the center of that for much of his career. I will note that he got his law degree from Lewis and Clark. just wanted to pass on. But apart from that, he's got a very notable career and background, which I encourage you to look into. He also worked at the Western Environmental Law Center, which, as many of you know, has been a major player out west and in the Northwest. Environmental issues. Let me introduce Gary Frazier next. I'm going to skip Bill just because you're on a different page. But Gary is the Assistant Director for Ecological Services at the U.S. Fish and Wildlife Service. He has been working at the U.S. Fish and Wildlife Service since 1984. So he has really been involved in Endangered Species Act and wildlife protection and the work of the Fish and Wildlife Service for many, many decades. And for those of you who don't appreciate this, as someone who has worked in the federal government and state governments with Fish and Wildlife Service, the commitment and dedication of that agency has been central to the implementation of the law. And you wouldn't always know that by virtue of the controversy and the headlines that play out. But it is the people within that agency, the managers, the scientists, the directors, that are able to make the law actually have real meaning on the ground. And then to his right is also one of our own, Bill Eubanks, who obtained his LLM here and then went off to work for Myers and Lichtenstein. Did I say that correctly?
Myers
Lichtenstein. I'm going to find your page here in a second. Thanks. You were just on the first page. But Bill has been doing some really impressive work in the years that since he left Vermont Law School, has been involved in a whole variety of Endangered Species Act litigation, as well as use of other federal laws, NEPA, Forest Management Act, the Clean Water Act. He's just been all over the field and has managed to land one of those perfect jobs where he gets to work for a private firm with all of the perks that go with that, including being able to now work out of Denver, Fort Collins, sorry, it's Colorado. But Bill is one of the rising stars in this area, and those of you who work in endangered species and wildlife law will have seen Bill and his writing, and if you are lucky enough to take summer courses here in Vermont Law School, you'll get a chance to take a course with him. So a very distinguished panel of folks and the perfect group to talk about this question. So I'll just start with, just some general thoughts. Why is climate change relevant to a conference on the Endangered Species Act? And maybe we'll just pass the mic down.
Thanks, David, and thanks everyone for coming. And yes, I have had the pleasure of having, I think, two of the towering figures of environmental law, both Pat Breno and Zig Potter, be mentors and friends for, I don't want to say how many years, let's keep that secret, but a good long time. And I just want to reiterate what David said, that the relationships and the friendships that you develop in law school are really important as you move through your careers. And both Vermont Law School and obviously Boston College Law School have wonderful people, and Pat and Zig are really true environmental heroes and have been fantastic mentors, and it's a real pleasure to have them as friends and mentors, and to have them be guiding both substantively and as role models through my career. As you know, on the front lines of the climate crisis, which we're seeing today, the White River is about as low as I've ever seen it. It's late October, instead of snow on the ground, it's going to hit 70 degrees. We are seeing climate change hit us much more rapidly than even some of the more dire predictions a few years ago were stating. And on the front lines of that is going to be wildlife and species. And we're looking at extinction rates of, depending on the numbers, somewhere between 1 and 6 to much higher than that within our lifetimes of species. The Endangered Species Act cannot solve that alone, but it is a critical tool in helping us try to plan to allow species to survive what's going to be very difficult times. We need to do a lot of other things. We need to keep climate change under control. We need to meet the goals of the Paris Agreement, which basically asks that global temperatures be kept below 2 degrees Celsius from pre-industrial times. And I think it's good to put in context that that is a ceiling. That is not something we can shoot past. That is kind of the furthest range of zone of comfort that scientists are willing to go. But ideally, we should be much better than that. We should really be in a 1.5 degrees Celsius range, which means we're going to have to do a lot of things to change our economy, to change our energy system in order to get the type of carbon reductions needed to avert what's going to be a host of impacts that all impact wildlife. As these impacts come online, and there are things like sea level rise and ocean acidification, more intense droughts, more parasites in Montana. In the west, we've seen huge die-offs of whitefish that have closed rivers like the Yellowstone. We're seeing moose not being able to survive anymore in northern New England because the tick infestation is so high. We're seeing salmon having difficulty surviving in the Pacific Northwest because temperatures are too high, stream flow is too low. These problems are going to intensify with climate change. How does the ESA play into this? In federal decisions, we have to be more careful to ensure that we account for these changes that are coming, that these changes that are coming are mitigated for, that we get out ahead of a lot of these problems in terms of listing species, that we look at habitat ranges differently, that we think about creative things like actually moving species to places where they can survive, whether it's moving them north, moving them up mountain, that we look at things like habitat corridors and protecting areas that maybe are not in the range of species right now, but need to be in the range of species. So we're going to have a much more proactive approach to allow species to survive what's going to be a very calamitous time. And I think we also might have to have a little bit of a paradigm shift too, in terms of looking at the ESA not as identifying a species in trouble, seeing a problem like DDT or a dam, fixing that problem, calling the species recovered and moving on, but look at it more as a long-term management tool where we really have to manage species to survive over decades rather than over years.
Thank you. Yeah, again, it's Mark Fink, Center for Biological Diversity, and I also echo Jim's words about Pat and Zagat's. As soon as I saw them on the agenda, I knew that I was coming here. It was really great to hear from them this morning. And the best thing that ever happened to the Endangered Species Act was TVA Hill going up to the Supreme Court soon after it being enacted and having that strong language come down from the Supreme Court. And we all owe a lot of thanks to Zig for making that happen.
And my students.
And the students as well. I've often thought of the Endangered Species Act as a Bill of Rights for the rest of the species on the planet. And TVA Hill, I've joked I sleep with it under my pillow at night to help me get to sleep because it helps calm me down a little bit. A couple of years ago, I was lucky enough to be able to speak on the Endangered Species Act at the University of Tennessee Law School. And in a way, I felt like I was going to Jerusalem to be that close to it took place. And now this morning, I got to hear from Moses himself.
Yeah. Moses got fired.
So the Center for Biological Diversity spent years and years and years working with Section 4 of the Endangered Species Act to get species listed, suing the Fish and Wildlife Service, National Marine Fisheries Service when they were missing deadlines, and kind of living a nice, happy life of having a relatively straightforward way of doing things. And then climate change came along, and I think the center realized pretty early on that if we just continued doing what we were doing and ignored climate change, that we were not going to be effective at all, that a lot of these species that we were saving under the Endangered Species Act were still not going to make it because of climate change, and that there were other species that needed to be listed solely because of climate change. And so right around the time that I got hired at the center is when they were really pushing the polar bear listing. The center led the effort on that to get the polar bear listed, and I think that was one of the first cases that the center saw really merged climate change and the Endangered Species Act. And at the time there was a lot of frustration over nothing happening in Congress, and so the polar bear listing I think gave a voice to a lot of activists that wanted to do something about climate change, but were being frustrated by Congress and other avenues. And ever since then, climate change has been instrumental in how we look at species listings, which ones we want to have listed, and how we go about protecting those species once they are listed. So it's very central to what the center does now. And we even have a Climate Law Institute as part of the Center for Biological Diversity. Thanks, Mike.
All right, Bill Eubanks. I want to start by also thanking our distinguished speakers from this morning. Zig, I think our firm has cited TVA versus Hill more than any other case, at least 10 times over. And Pat, I did my LLM here. I finished 8 years ago, and I took Extinction and Climate Change, I think as it was called at the time. And it really opened my eyes to the biodiversity crisis that we're facing now. And I actually think, to keep my remarks fairly short, I'm going to use an example that I learned in that class that I think is relevant to the rest of this discussion. Pat wanted us to write about, pick an endangered or threatened species and look at how climate change is affecting it. And I said, I really want to look at a species that's not yet endangered or threatened, but will be if we're not careful. And so I chose the iconic New England species, the sugar maple, Acer saccharum. And I decided to write a paper on it, which then turned into a law review article. And what I wanted to look at was the Regional Greenhouse Gas Initiative, RGGI, which had started a few years before my time here. And the thing that was most striking to me, and this is something still happening right now, is we're seeing the range of these plant species and the animals that depend upon them moving northward at a pretty precipitous rate. And if I'm remembering the facts from my paper correctly, it's been 8 years, but over 50 years, the maple syrup production had flipped from 80% being done in New England and only 20% in Canada to the complete inverse of that, with 80% by 2008 being done in Canada, simply because we don't have the availability of the trees to make the syrup anymore. And so that is indicative of this climate change problem we're seeing. And the sugar maple, of course, is not going extinct. It's not going extinct anytime soon, and it may not, ever. But it is showing how the zones are transitioning. We're seeing the animals and the plants move, and we have to figure out how we can make federal policies fit that narrative. How can we make them reactive so that they aren't just looking at what a species needs today or tomorrow or next year, but what does it need next century? And that's something that's critical that I don't think the law really addresses at this time. So I'll leave it there. I know we have some other interesting questions coming.
I'm Gary Frazier. I'm with the U.S. Fish and Wildlife Service. I think I'm the oldest guy up here on the panel, certainly, and one of the oldest in the room. I have been around for a while, but I still have a lot to learn about the Endangered Species Act and what people think about it. So I'm looking forward to today. This is going to be great. I have to join the fan club of Professors Parento and flattered. The act is more than just the words on the paper. It's more than just the regulations as such. It's about how you actually make it work in the world that we live in. And both of these gentlemen are as wise and insightful about that broader perspective as anyone that's out there. So you're all blessed to have them here and be able to learn from them. So
could you put a word in it during my evaluation next year?
Absolutely.
Gary, you're fired.
I did tell Dr. Platter, I thought his book was actually one of the most insightful treatises on the Endangered Species Act in the real world. It's not the current modern world, but it reflects many of the things that still exist today. So it's a great pleasure to be here. So getting back to the topic at hand, climate change infuses every aspect of how we administer the Endangered Species Act today. I don't think the drafters anticipated this at all, but the wisdom that they had and how they structured the act allows us the latitude to be able to incorporate climate change in everything. What species warrant listing and how we make those determinations, many times having to model and predict the effects of climate change in the foreseeable future. What recovery looks like, how you structure critical habitat designations that actually identify those areas that are essential for conservation in the future with a dynamic physical environment. Many things that we're learning as we go, and it's going to continue to be a challenge for us. But I think the most important value, or this most significant value of the Endangered Species Act and climate change is that people care about wildlife, and the Endangered Species Act allows us to interpret the effects of climate change into concrete terms that people value. We listed polar bear because it was in fact threatened, but by doing so, we made in concrete what the effect of climate change was having on our polar ecosystems. And this iconic creature was at risk of disappearing. Those are the sorts of things that I think provide the greatest value from the Endangered Species Act and how society understands the significance of climate change and motivates themselves to do the very hard stuff that's going to be necessary for us to deal with it.
Thanks, Gary. So just a quick note on format. What I'm going to do is kind of ask a series of questions, and any one of you that want to respond, feel free to jump in and counter or react at any point. And at some point during the students will be handing me some questions from the audience that have been tweeted or texted, and I may throw some of those in. But just to start out with, and building on the polar bear example that Gary just described, we talked when we convened earlier about the issue of kind of foreseeable threats. You know, there's existing threats that we know about today, but in the light of climate change, there's a whole new host of foreseeable threats. And how does the Act, or does the Act allow us to take that into account in how we make listing decisions or designate critical habitat? Anyone want to take a stab at that? Let Gary say first.
Actually, I'd never seen that signing statement from President Nixon before, but they're focused upon one of the most significant changes that was made in the Endangered Species Act. It was looking at also protecting species that were going to be in danger of extinction in the foreseeable future, not those that were just in danger of extinction right now. That is something that's a very powerful element, but also a very controversial part of the Act, because looking into the foreseeable future, we are having to make assumptions. We're having to use, in many cases, models. We don't always see the effects that we anticipate reflected in the status of the species right now. We're a society that is pretty risk averse in many cases and wants to actually see that and have empirical evidence that those threats that we anticipate are actually going to be carried out. So that's a hard part for us to deal with, and even within frankly, the wildlife conservation community. Many of our state fish and wildlife agencies have a difficult time accepting that the Endangered Species Act would come in and overlay protection of a species that had previously been under their sole domain because of effects that we anticipate in the future, but we're not seeing right now. So these are hard aspects of the way that we administer the Act, but I think also absolutely essential if we're going to be successful in the conservation mission. If we wait until species are at the brink of extinction, we're often going to be too late, as was noted earlier today.
Yeah, I would just add that, so the definition of threatened species brings reasonable foreseeability into the picture. The Fish and Wildlife Service, National Marine Fisheries Service are charged to look at the foreseeable future to see what species are going to become endangered down the road. And that is one of if you read the decision on the polar bear listing, the Fish and Wildlife Service determined that within 45 years, based on the climate science, that the polar bears would become endangered. And they looked at 45 years. One reason was because that was 3 generations of polar bears, but also just because that was looking at the climate science again, that's where they had the strongest footing to make that case. One of the things that struck me reading some of these cases where climate law and Endangered Species Act merged is just how much it really gets back to administrative law principles that we're all very familiar with. The judges are falling back on principles that they've been working with for decades to resolve these issues. And so, as long as the Fish and Wildlife Service, National Marine Fisheries Service are looking at the best available science and explaining themselves well, and making a good case for what they're doing, the judges are still going to ultimately end up deferring to them 9 times out of 10. And in that case, the judge says that time after time that it was actually attacked on both sides. The Center for Biological Diversity and others thought that the polar bear should have been listed as endangered immediately. The industry was fighting the listing as threatened, mostly claiming that the climate science wasn't certain enough. And the judge found that they had struck a good middle ground if you refer to their decision. But yeah, so again, the reasonable foreseeable is really built into the statute, and agencies are trying to look at it.
Yeah, and I just want to add that, when talking about best developed science, the case law is pretty clear, I think the statute is pretty clear, that there doesn't have to be absolute certainty in that science about what the impacts are going to be. There's a relative degree of certainty with a lot of species that they will be impacted and they will be imperiled by climate change. Some of the specifics, the time frame, things like, well, what will the world do? Will we see 2 degrees of warming? Will we see 4 degrees of warming? Will we see 6 degrees of warming? There's uncertainty there, but that level of certainty isn't needed necessarily to list a lot of species. And I think the more we get out ahead on species that are going to be in trouble, the science clearly tells us they're going to be in trouble, the better the chance we have of saving those species. And I think the less controversy we're going to have down the road.
William, anything?
Yeah, I think one of the biggest questions, I don't work for the Fish and Wildlife Service or for NIMS, but I think one of the most difficult things is, each species is different. Its life cycle is different. Someone pointed to the polar bear and how they focused on 3 generations. And so I think one of the difficult questions facing us is, should we have standards in place that kind of apply across the board, or is it really a species by species type of approach? Should we have some kind of confidence interval or p-value or something on a population viability analysis that would, sort of apply across the board as a general matter? But the problem is that doesn't, work necessarily in the biodiversity world. And so I think, it's something that my nonprofit clients I know grapple with daily, is they would love to have some standards about what is foreseeable and how many years do we look at. Do we look at 30? Do we look at 50? Do we look at 100? But at the same time, that almost is an overly restrictive and too constraining of an approach, given how different each species is. And so I think, it is one of these things where right now it is case by case, and as Mark said, for better or for worse, courts are deferring most times whether the decision is to list or to not list, because either the science shows that the climate change requires listing or it does not warrant listing. So for now, that's sort of the limbo zone we're in, and that may be where we stay. But to the extent that the conservation community could come together, scientific community, and come up with a standard that could at least be a general rule that then you could extrapolate from if you needed to on a particular circumstance, I think that could be helpful. But I just don't know if that could exist in the conservation biology community.
So I have a kind of a related question, and digging down maybe a little deeper into the weeds relating to recovery plans. So as you all recall from Pat's crashing into you with his course on the Endangered Species Act, there's this idea of a recovery plan, right? If there's a species that is threatened or endangered, we should have a plan to get it off to help it recover. And so we have the Fish and Wildlife Service and National Marine Fisheries Service developing recovery plans. Should these recovery plans be developed in a way that anticipates the need for a habitat that maybe isn't even protected now or isn't necessary or critical, but we anticipate it will be needed, as the species needs extra room to adapt or move. Could take the big-nosed thrush as an example. If all the habitat keeps moving up the mountains, at some point in the mountaintops in Vermont will not be high enough. Where do we build into this recovery plans the ability for the big-nosed thrush to go someplace else?
Yeah, I think if we don't administer the act in that way, it's going to be useless for a lot of species. I think we really, both in terms of designating critical habitat and in looking at recovery, I think we have to look at not where the species would recover if we assume what happened in the past is going to happen in the future. But I think we're going to have to look at what the trajectories are and where in 50, 100 years the species population is going to be viable. And I think we might actually have to take some proactive measures under, for instance, 10J to perhaps introduce some populations or move some populations and help those species either through actually introducing experimental populations or preserving the type of habitat corridors necessary for them to move themselves, so that way they can move into habitat areas that are viable for them.
Jim, let me just ask you a follow-up question and kind of continue to all the remainder of the panelists. Do you have any examples in mind? I mean, I think it might help the audience if you had some specifics of a particular species where we're trying to anticipate their future needs based on the climate impacts.
Well, I think, you know, you can take a species like the pika, which is, you know, that's a species, it's going to be hard for them. I mean, they move up, they don't move north. So are we going to have to take the pika and move the pika north? You know, the Wolverine southern habitat is probably going to become not snowy enough for it. Do we have to be cognizant of allowing that species to move north? I mean, you know, another thing might be actually protecting, doing a better job of protecting areas right now that are very viable for certain species, and I'm thinking of, you know, salmonids. But unless we do things to ensure that the streams stay cool and the flow keeps coming, you know, they're not going to be, you know. So we might have to account for instance, that our current land practices might make streams viable for salmon, but in 50 years, those current land practices are going to make the streams too dry and too warm. But if we change our land practices, we could keep them at a level where the salmon can adjust. So I mean, I think we're going to have to be thinking of those terms.
I would just add, I think the recovery plans might be where it gets the most complicated when you're looking at the intersection of the Endangered Species Act and climate change. One example I've looked at recently is a recovery plan for some coral reefs down in Florida area, whereas National Marine Fisheries Service recognized that they needed to include ocean acidity and ocean temperatures in the recovery plan as objective criteria for how to get those species off of the list of endangered species, which is great. It was a really big step, I think, but it also identifies a potential problem is, well, what can National Marine Fisheries Service really do about ocean acidity and ocean temperatures? And so, you know, I think a lot of these times, you know, we do the best we can under the Endangered Species Act, and even the agencies are doing all they can, but you still come back to Congress. It's time for you to step up and look at the bigger picture here, because we're all doing our best down on the ground, but we need more, you know, stronger laws from Congress and throughout the world to, you know, really identify what the main problem is and address it.
Briefly, I agree with what's been said, and I think recovery plans are, you know, an important part of the act. I'll briefly note, however, that as Pat mentioned this morning, recovery plans are not enforceable, as most courts have held, nor as a result of a DC Circuit ruling 2 years ago, do the services have to actually follow their delisting criteria when that are set forth in a recovery plan when making their delisting decisions, or downlisting decisions. So I think recovery plans have value, but that value might be limited as courts have circumscribed that role.
Well, thank God recovery plans are not action forcing. Recovery plans are a roadmap for how to seek recovery of species. They absolutely have to consider future conditions. In some cases, we cannot identify effects that are reasonably certain. We can plan for those and actually achieve recovery even in the face of climate change. So a perfect example might be tidewater gilpin. It's an estuarine species on the west coast. Requires nearshore shallow water habitat. Sea levels are rising as those waters rise. If the shoreline is hardened, those shallow water habitats near shore are going to disappear. So the recovery plan and our critical habitat serves to focus upon that threat and says we need to be protecting lands inland so that as sea levels rise, there is still shallow water habitat that's going to be available for tidewater gobies into the future. So that's an illustration more of the simple case. The harder case, the species like polar bear. And there are many other species that we're going to see like this in the future where we don't see the path to actually recover these species in the, at least the foreseeable future. There's enough carbon in the atmosphere right now that we are going to lose, at least scientists predict, we're going to lose the nearshore sea ice platform that polar bears depend upon for their survival. And unless the ecology of those bears changes, we're probably going to lose polar bears from Alaska, most of the Canadian Arctic. We think that there will be in the Arctic archipelago still an area where we will continue to have sea ice or shallow water is productive enough to maintain a food base for polar bears, seals, etc. But it's going to be a long time. We hope that we still have polar bears on the Earth by the time that we're able to turn around climate change. So our recovery strategy is not so much recovery, it's about a conservation strategy. How do we protect the bears, give them the maximum ability to persist until society acts to undo the loading of greenhouse gases into the atmosphere that are causing these sorts of physical changes. It's something that we've never done before. It is a painful thing to contemplate, but that's the task that we've got. And I think the broader conservation community has to get their head around how we think about conservation in that sort of much more dreary, dismal sort of perspective. That if we're going to protect those species that are really near and dear to us, we're going to have to be looking at that in a really frank and honest fashion and doing our best moving forward. That's what we're doing right now with polar bears. We'll be doing this for, I think, many other species.
Add quickly to that, just to kind of get perspective to the type of challenge we have before a lot more species fall into the polar bears category. We have to, by mid-century, not just zero out our emissions, but start having a net sink of carbon from our energy sector. And that means not just not developing new fossil fuel reserves, that means not developing the fossil fuel reserves currently under development. It's doable, but it's a challenge. And I think it's really the challenge of our time, because if we don't hit that goal, if we don't hit the Paris goal, I think we're at a point where the Endangered Species Act is going to be under more pressure than we can bear.
But both of you have kind of opened up the door to another question we talked about, which is if there are species that are doomed, how do we deal with that? How does the Endangered Species Act deal with that? What's the right policy to address that? And given how gloomy and dreary that particular question is, let me follow up and give you a chance to weigh in on the backside of it with, are there ways in which we can use the Endangered Species Act to really begin to attack the kinds of questions that you just raised, Jim? Are there things that we can proactively use the Act to do that will stop the causes of climate change, or at least slow it down? So two-part question. What do we do about species if they're doomed? And I assume, given the rate of extinction that Professor Parento described, that's happening on a daily basis. How much time and energy and resources should we spend on those? But are there other ways on the flip side of that we can use the Act to really make a difference?
Well, from a conservation standpoint, we don't know which species are going to be doomed. So, as the Act is currently written, my personal view is we should be conserving and protecting each species and trying to help each one persist as long as we can to hopefully reverse these effects. So, we don't know which ones are going to ultimately make it and which ones aren't. So, I think we should be conserving all of them to the best of our ability, using the resources that Congress is willing to appropriate. In terms of what we can do, I think it's difficult to use the Act as written to halt climate change. But what I think is really important, and I'm glad we have this opportunity. A lot of what our firm is focused on, and I know we're going to talk more about renewable energy later, but is avoiding what I call additive forms of take. So we know climate change is going to have serious impacts to birds and bats and whales and every other species. So it's imperative under the Act that we take all steps possible using citizen supervision and other tools to reduce, if not eliminate, additive forms of mortality, because that will help provide a buffer or a cushion so that these species can persist even longer. So, whether you're looking at a hydroelectric dam, whether you're looking at a wind energy project, whatever the issue is, there are always ways to minimize, if not eliminate, mortality from those sources, communication towers, to minimize that mortality so that then mortality that is caused by climate change is lessened. The impact of that to the species as a whole is lessened. So I think that's quite critical.
So I'm very glad that the Endangered Species Act doesn't direct us to play God and choose which species are listed and which are not, because some are lost causes. We list them when they're in danger of extinction now or in the foreseeable future. That doesn't mean that we're going to be successful. And it certainly doesn't mean that we're going to invest significant resources into lost causes. We haven't really crossed that threshold yet, but it's bearing down on us very fast. It doesn't take a rocket scientist to understand that key deer, key largo wood rat, many of the listed species we have in the Florida Keys, they're probably not long for this world. Within the lifespan of my kids, we may lose them because their habitats will be inundated. Those are things that we're going to have to look at soon as to whether we're going to invest our limited treasure into trying to recover those species, or whether we're going to put it elsewhere where we have greater opportunities to actually affect conservation, meaningful conservation in the long term. But that also doesn't mean that we just turn a blind eye to those. It's in those situations that, again, the Endangered Species Act is a big spotlight. It's a bully pulpit to put in concrete terms, in terms of species that people care about. What are the consequences if we allow climate change to continue to have the effects, to continue to affect our environment the way that it is? And that's one of the great powers of the ESA.
I would just add, at the Center for Biological Diversity, I know that we're not thinking about doomed species, and we're fighting for all species, great or small. And I think for a couple of reasons. I mean, one, we think every species has inherent value, and that we don't care what the human connection might be to that species. We're there to fight for the species itself, and down to its last breath as a species. But also, nature is a lot of science, but it's also something more than science. And we don't know what species might rebound down the road that we never thought would. We just don't have the scientific knowledge to make those determinations. And so, whether it's hoping for a miracle or not, we keep fighting for every species.
Yeah, and I think when it comes to doomed species, we've got to prepare for the worst and hope for the best. And I think playing God is a difficult place to be in, and I think we make a lot of wrong choices. So I think it's important to fight for all species and hope that some rebound, and also hope that we get the climate crisis under control as quickly as possible. In terms of the ESA's value, kind of from a carbon reduction standpoint, I think it's the good growing, and I think relatively consensus opinion that the ESA is a bad tool for direct carbon regulation, and that the Fish and Wildlife Service is probably not the agency to be doing that. That's something that Congress needs to do, and the EPA needs to do. We have other laws to do that, and those laws need to be aggressively pursued. That said, I think the ESA can play a very important role in highlighting why we need to aggressively make those carbon reductions. And I also think that the ESA can be a very powerful tool in highlighting some of the other things we need to be doing to help species survive climate change. And I think one thing we need to really be cognizant of is that the healthier we keep our ecosystems as functioning ecosystems, the better off these species will be. The more we destroy the natural functions that help systems withstand stress, the less stress they're going to take, and the more species are going to be impacted.
I'm going to turn to a question from the audience and kind of follow up on that. What are some things? All right, so Fish and Wildlife Service, maybe they're not the right agency to regulate carbon emissions. We hope EPA will be found to be the right agency to do that work. But as Professor Parenzo noted out, there is this section of the Act that requires consultation You guys remember what section that is? 7, right? So section 7 consultation. So there are federal agencies that are making decisions that have a significant impact on climate. New highways, new dams, new wind projects. See, some of these are good, some of these maybe not so good. But consultation plays into that set of decisions. It's consultation a way that the U.S. Fish and Wildlife Service and NIMS can use their power, their absolute power under the Endangered Species Act, to force the rest of the federal government to actually step up to the plate. What do you guys think?
Yes or no? This is a question for lawyers, actually. It's causation. You know, Section 7 looks at the effects of federal actions on listed species and their designated critical habitat. You have to have a causal connection between the action and those effects. So the question is whether we have the scientific ability now to demonstrate in a reasonable fashion, something that we can defend, that this emission, when added to the billions of tons of carbon already in the atmosphere, causes an effect for that species or that critical habitat there. It's our view that right now the science does not allow for that kind of fine-scale causal connection to be established. It may at some point in the future. I hope after I retire. That really is why right now I think Section 7 is not an effective tool for evaluating and being able to bring the prohibition against jeopardy or destruction of adverse mod that's in Section 7 into the aspect of controlling emissions of greenhouse gases.
I think there's another valuable role that consideration of climate change can play in consultation, and that's looking at the effects of climate change compared with the project, and not just using what's happening currently on the ground or what's happened in the past, but look at what's going to happen in the future. You know, are the mitigation steps, for instance, that a proposed project is going to take to help the species, are those going to withstand the type of changes we're prepared to see under climate change? Better consideration of the fact that species are going to be more vulnerable under climate change to calamitous events that may put stress on them. You know, for instance, I mentioned the whitefish die-off in the Yellowstone River. We're going to see more of those. We've already seen those in the Pacific Northwest with salmon being stressed by either parasites that they're not used to be stressed by, or low-flow, warm temperature situations. So is that project and some of the mitigation measures, when combined with those foreseeable impacts, going to have an effect? I think making sure those become part of the consultation calculus is very important, and I think those are things that Fish and Wildlife Service can consider now.
Just to back up one sec, there's both under the National Environmental Policy Act and the Endangered Species Act, agencies need to look at climate change in two different contexts. One is what is the impacts of climate change on that project, and the other is what is the impact of that project on climate change. And NEPA is starting to address both. The Endangered Species Act is really more focused so far on how is climate change affecting that proposed action. You know, whether it's a river drying up that's impacting the fish, or as in polar bear, sea ice is melting. And the agencies and the courts have been pretty successful in figuring out how, you know, what the proper context is for that and how they're going to address that going forward. The more difficult one is what we're starting to get into talking about now is, you know, how is this project, if it goes forward, going to contribute to climate change, you know, through greenhouse gas emissions primarily. And that's, again, through NEPA, they're starting to address it a little bit. In the Endangered Species Act, it's more complicated because you have to draw that connection not only just to the environment in general, but to a species, a particular species somewhere. And that's where you get into that causal relationship. And, you know, I do see down the road, hopefully soon, that we'll find a good fact pattern where we can make that case. And it will be up to good lawyering and good experts to do so. You know, as with any other new type of litigation, you want to find the best facts to bring your first case and then go from there. So, you know, start looking at what's out there. And one thing that's out there is the federal government is doing a nationwide environmental impact statement on its coal program. Coal is on federal lands and what they should do about those lands moving forward. So if you look at the emissions from all coal on federal lands, that's pretty significant. And perhaps that will be one of the first fact patterns that attorneys will be looking at.
I'll keep it brief. Everything that was said, I mean, it seems like this is all in the should category. This is how it should work. It all sounds great, and if you read Section 7 on paper, that's how it should work. As we know in practice, as the proceedings from the National Academy of Science study that was mentioned earlier, the services rarely, if ever, find jeopardy, despite the fact that conservation biologists see a lot of situations that are causing jeopardy. One of the problems I see with the Section 7 process in general, which I think is relevant to this climate change question, is biological opinions are done at the field office level. This is not direction coming from headquarters in DC. And as a result, biological opinions are often very sloppy. You'll see cut and paste jobs of 10 or 15 pages at a time, and you can tell it's for a different project where it wasn't even proofread. So the fact is there are inherent systemic problems with how the biological opinion process is done. And I don't have a lot of confidence based on what I've seen from different field offices that this is going to be implemented on a nationwide basis. So, I think there should be a call from headquarters from both them and Fish and Wildlife Service to start looking at these issues from a holistic, comprehensive standpoint. I think we should incorporate climate change in that new framework.
Well, I just add my editorial opinion that without taking a particular side based on parties, that it matters. Like elections matter, and the leadership of the federal agencies matter. And having a president who acknowledges the importance of climate change matters. And when the federal agencies all get together, the secretaries or the managers, and are directed to solve a problem, it matters whether or not the U.S. Fish and Wildlife Service or National Marine Fisheries Service have the support of the president. It also matters whether they have resources and whether the Congress, the Senate, and the House have appropriated sufficient resources for them to do their jobs. So a lot of this unrealized potential of the Endangered Species Act is not simply a matter of changing the law or the regulations or getting better court decisions. It's a matter of electing the right kind of leadership, for what it's worth. So let me turn this question around slightly, and I'm going to turn to you, Bill, because I know you've been at the center of some of this discourse, which is the Endangered Species Act impeding efforts to address climate impacts? Are the Endangered Species Act cases that have involved challenges to wind projects, for instance, a reason that we should think about the Endangered Species Act differently? Is it true that you actually hate wind projects?
Yes. No, this is one that Pat and I have had lots of good conversations about. My firm has been involved in I believe the first successful federal environmental lawsuit against both an onshore project, the Beach Ridge Wind Energy Project in West Virginia, and offshore project, the Cape Wind Project. And in both cases, we were bringing them on behalf of national nonprofit organizations. In both cases, we wanted to see the project ultimately go forward, and I believe the Beach Ridge project has, and Cape Wind we'll see. But in both cases, what we were trying to accomplish, and this is true with the current cases challenging solar projects too, is how we can use the law to ensure that projects go forward, but in a much more wildlife-friendly fashion. What we want to make sure of is that with this relatively new technology of renewable energy, which is going to help us solve one of the greatest crises of our time, climate change, hopefully, that we don't create a new ecological catastrophe as a result of that. And when you look at other forms of energy, whether it's hydroelectric, nuclear, they all have their downsides. And the fact is, wind and solar have downsides too. They may be carbon neutral, but they can have huge wildlife and wetlands impacts. And so a lot of it goes to responsible development in the siting process and very early on. And so the key thing with this is, well, I'll use Beach Ridge as a concrete example. The project was expected to kill, and this was probably a very conservative estimate, 200,000 birds over the course of 20 years, many of which were highly imperiled species, as well as 130,000 bats. And as a result of our lawsuit, an incidental take permit has now been obtained under Section 10 of the Act, and that number has been slashed to 2% of the original mortality estimate, and the project will only lose 0.2% of its profits, 0.2%. So for very, very minimal profit loss, they were able to reduce the mortality by many, many magnitudes. And these solutions exist, and we know they do. There are lots of engineers and scientists working on this. So that's the real question. It's not can we do renewable energy, but can we do it responsibly? And so I think the ESA can be harmonized with renewable energy, and we need to focus on how to do that. And I think a key, I'll pass it along because I know I've been going for a bit, but I think a key when you have a federal entity involved like the Cape Wind project is not to put a thumb on the scale. Just because it's renewable, we can't give a green pass. It's not a special type of project. We have to look at every form of energy just like we would, whether it's a coal-fired power plant, a hydroelectric dam, and look at its pros and cons in an objective fashion. And that's essentially what the DC Circuit held in the Cape Wind case did not happen for the Cape Wind project, is the federal government put a thumb on the scale, and by doing so, they skewed the entire Endangered Species Act review. So we need to ensure that the federal government serves as an umpire, calls balls and strikes, looks at every project on a case-by-case basis.
Yeah, I kind of want to add to that. I mean, not only I think can it happen, but it has to happen. I mean, otherwise, that's the only way we're going to combat climate change is to build renewables and build it at an incredible pace and scale. I think another thing that's very important is I think culturally, both nonprofits and the renewable energy industry have to approach this differently. I think for projects to come online at the pace needed and with the type of responsible measures needed to get to the numbers that Phil was talking about, which is much less mortality, much less risk, which is doable, the technology's there. The earlier that stakeholders can get together and map out problems and take time up front to do that, I think the better and the quicker ultimately we're going to get a lot of these projects online. Just to bring up another renewable energy project, which is the Block Island Wind Farm, which is the first offshore wind farm to be built. I think that was a great example of deep water wind coming to NWF, NRDC, Conservation Law Foundation, other groups saying we want to do this the right way. We know there's going to be runway impacts. We want to make sure that we account for those impacts. They sat down, worked out an agreement. It actually went further than Fish and MIMS would have otherwise. That project is now built and about to go live. Similarly, and this is a case where the government got involved, and it's the Top of the World Wind Project in Wyoming, which was taking golden and bald eagles. Unfortunately, there was an action by the government, but the result was that the wind farm, which is a 200 megawatt wind farm, was able to put in technology that basically has stopped those mortalities, and it's affordable technology and it's there, so it can be done. It can be done in the pace and scale needed.
Just a couple of quick thoughts. One is, since I've been a part of the Center for Biological Diversity, this has been one of the most robust discussions within the center itself, is whether or not to challenge a particular renewable energy project. And you've got usually on one side the local activists that are really fighting to protect a particular species that might get impacted by that development. On the other side, the climate law folks or the climate change focused staff that are thinking more globally and how this is going to be needed long term. And so one thing I would say is that whenever you see a local group fighting a renewable energy project, I think you don't want to just assume that they're doing some knee-jerk reaction, but that they really do know what they're doing, that they've thought through this very clearly and have made their decision, and that it probably wasn't done lightly at all. Second, I think sort of looking at renewable energy more broadly, I think climate change presents us with a really unique opportunity as a society to figure out how we want to live, and that if we just continue forward with our current population and consumption mindsets and just try to flip that over to the renewable energy side and not slow down at all and really, again, rethink how our communities are set up, I think we're losing a really big opportunity, and we could be really empowering communities and homeowners to take control of their power sources and their communities, as opposed to letting industrial corporations determine where these things are going to be sited and how they're going to let us access them when we need them.
Anything you want to add, Gary?
Well, we're just about out of time. If I could, I'd like to ask each of you just if you share like one thought with the students in the audience. You know, if there's one thing that you would want them to do in their careers that involve the use of the Endangered Species Act to address the issues of climate change, what would that be? And while you're thinking about that, I just want to share that this morning, as I signed onto my phone, which I now use in place of a newspaper, I was greeted with a tweet from the Vermont Fish and Wildlife Department, which had posted the sightings of 2 Canada lynx in southern Vermont just yesterday, which I thought was somewhat auspicious given today's events. So we've got some things blowing in the right direction.
I don't know if this answers it directly, but I spent a lot of time thinking about this, that really there's no more important time to be alive in the world's history if you want to work on biodiversity issues. And this is, you can't get more critical than the situation we're currently in. And it's both depressing and incredibly exciting to be born and being able to work at this time in global history. And also, when I was in law school, I decided pretty early on that humans had enough lawyers, and that every other species did not have nearly enough lawyers, and that I was not going to be an attorney for humans, I was going to be an attorney for everything else on the planet. And I think that's more true today than ever before, that the more that we can get attorneys working on helping out the other species on the planet and get away from the human-centric legal system, the better off we're going to be. So I encourage you to keep going down that road.
Yeah, I mean, I think I might myself don't have to directly answer the question either, but while in some ways it's depressing and we're kind of staring at this abyss, in other ways I think it's a really incredible opportunity to go back to Mark's point about kind of rethinking and remaking the world. While there's going to be impacts, there's also an opportunity not just to avoid a lot of those impacts, but I think to really make an economy and an ecological mindset that's much more feasible than the extractive mindset we've had. And there's going to be some losses just because we put a lot of carbon into the air. But I think as lawyers using the Endangered Species Act and other acts, I think we could really rethink our world and have the type of standard of living that we enjoy in a modern society, but do it in a way that has a much smaller footprint on our natural systems and on our wildlife.
Well, as I look out at all of these bright, shining faces, smart people that want to go out and change the world, I remember when I was like that, it was a long time ago. It's really energizing for me to see this. I would ask all of you to, at least one of you, to commit yourself to being the person that's going to help to bring on ESA version 2. I love the Endangered Species Act. I think that it's an incredibly insightful and powerful tool, but I frankly worry that it's not up to the task that's ahead of us. We're looking at a pace and extent of environmental change that's going to swamp our ability to deal with it species by species. It's very difficult to get anybody to step up to the table and even talk about, okay, what's the next model that's going to be effective for species conservation in this incredibly rapidly changing physical world that we have. It turns into biological consequences, but somebody's got to do it. And I hope that it's going to be some of you. You're going to have to dedicate yourself to understanding the law and the policy and the science so that you can be wise and insightful as the folks who drafted the Endangered Species Act 1973.
And with David's permission, I'm going to do 2 quick ones here. First, I think I'm a big proponent of citizen suits, and especially when they're done, they're well thought out and strategic and well developed. And so my advice would be think outside the box. Look at what people have not yet done, because there's a lot of opportunity. And again, focusing on additive forms of mortality, think about things like oil and gas and big agriculture. There are so many opportunities of soil and pesticides and fracking fluids and other things getting into our rivers where endangered species live. So it's just a matter of finding scientists who can help prove your chain of causation, and if you have a good suit, there's a lot of opportunity out there. So I think, be creative, think outside the box. My second one, this is more of a career type piece of advice for the law students and young lawyers in the room. Find a great mentor. If you care a lot about the Endangered Species Act, find someone like Zig, find someone like Pat. I was fortunate enough, and it sounds like some others were, to take Pat's classes, and he's the first person to tell me when I do something silly in an ESA case, and he's also the first person to pick me up and congratulate me when I win an ESA case. So find someone who can show you the ropes, because this statute may look deceptively easy, but it is incredibly intricate and difficult. So find a good mentor.
On that note, please join me in thanking this amazing panel.